This is a voting rights case. It's brought here on appeal by 11 Tennessee voters who seek federal court protection to end flagrant discrimination against their right to vote.
What's this? This is the oral argument in Baker versus Carr.
These 11 Tennessee voters live in 5 of the largest cities of Tennessee. They are the intended and actual victims of a statutory scheme which reduces their right to vote to about 1/20th of the value of the vote given to certain rural residents.
Who's he?
Charles S. Ryan, the attorney for the appellants who were the plaintiffs in the district court.
Since the right to vote is the greatest civil right, these appellants bring their case here under the 14th Amendment in the Civil Rights Act.
Sounds like important stuff.
Chief Justice Earl Warren once commented that of the many major decisions handed down during his 16 years on the Supreme Court, none was as important as this one.
Okay, well, let's hear about it. What's this case about?
Well, this case arose from a lawsuit against the state of Tennessee. Charles Baker, the mayor of Millington, Tennessee, sued Joe Carr, a representative from the state of Tennessee.
What for?
Baker said that because he was a citizen of a larger populated voting district, his vote wasn't worth as much as the votes of folks who lived in more rural areas.
Huh?
The law in Tennessee said that all towns must report their population statistics every 10 years.
Okay.
This information was used to draw the boundaries of the legislative districts so that roughly the same number of people lived in each voting district.
I see. And so, what was the problem?
Tennessee hadn't redrawn their boundaries since 1901.
And what year was this?
1961.
Let me see if I understand. In 1901, according to your mathematics, 11 counties had a larger representation than they were entitled to under the Tennessee Constitution.
That's right, Mr. Justice.
And since then, that disparity has increased merely because nothing was done since 1901. And there's been a shift in the population between rural and urban. Is that right?
That's very true.
Okay, I'm starting to get it. Since rural communities were less populated, their vote counted more somehow?
Yes.
I say there's nothing in the Constitution of the United States of America and nothing in the Constitution of Tennessee that said it takes 20 city residents to equal one farmer.
That's funny, but I'm still trying to do the math. What does he mean by 20 city residents equal one farmer?
It has to do with their electoral votes.
Okay.
Charles Ryan later gave this example. Let's say that in 1961, Moore County has 2,300 voters, and Shelby County has 312,000 voters. Moore County has 1 electoral vote, and Shelby County has 7 votes.
I get it now. Moore County's 1 electoral vote would equal 2,300 voters, but each one of Shelby County's electoral votes would equal almost 45,000 voters. That meant that a Moore County voter had 20 times the voting power of a Shelby County voter.
Exactly.
No wonder the Shelby County voters were mad. So the people in the more populated areas were like, hey, we want our vote to count just as much.
They wanted equality. 1 person, 1 vote.
Ooh, catchy. I like that.
The plaintiffs admitted that although Moore and Shelby counties had a 20-to-1 ratio, the average across the state was only 10-to-1.
Still, that's worth fighting for.
We're not arguing for absolute mathematical equality here. We're asking for the reasonable equality required by the 14th Amendment.
14th Amendment. Equal protection of the law. Sounds fair. What did the defense argue?
The defense argued that redistricting was a non-justiciable political question.
What does that mean?
Well, the idea is that some matters are so political in nature that their resolution is best left to the elected branches of government instead of the courts. In this case, there are many different considerations that must be taken into account in drawing the boundaries of voting districts. So the courts are not the ones best qualified to balance competing interests and come up with a solution that works.
I think basically here, the argument does turn on a question of what is the proper scope of judicial power. Is it worse for the legislature of Tennessee not to reapportion? Or is it worse for the federal district courts to violate the age-old doctrine of separation of powers? This court doesn't carry the whole burden of government, and for it to rush in to try and deal right political wrongs, instead of leaving them to the other branches, the political branches of the government, could impair its usefulness in our constitutional system.
Whoa, that's intense. I think he just suggested that if the court gets involved in political issues, it could lose its usefulness.
He did suggest that, and that's partly why it took the justices nearly a year to hand down their opinion. They simply did not agree.
And probably just wanted to get the decision right.
Justice Felix Frankfurter, along with John Marshall Harlan II, argued that the court should exercise judicial restraint because of the damage the courts might suffer by intervening in political matters.
The court's authority possessed neither of the purse nor the sword ultimately rests on sustained public confidence in its moral sanction. Such feeling must be nourished by the court's complete detachment, in fact, and in appearance, from political entanglements, and by abstention from injecting itself into the clash of political forces and political settlements.
Frankfurter insisted that any voting realignment should happen through the political process. However, in the end, Justice William J. Brennan delivered the opinion of the court, with 3 concurring opinions and 2 dissenting opinions.
What did they decide?
The opinion of the court was that redistricting was not a political question.
So, did the Supreme Court change the voting district boundaries in Tennessee?
No.
Oh?
They remanded the case back to the federal district court, where it had begun. It was then up to the district court to decide how to make things more equal in Tennessee.
Okay, so they said, District Court, you deal with the redistricting issues. We're just telling you that you need to do it.
Yes. On remand, the district court determined that the 14th Amendment's requirement of equal protection in legislative apportionment would be satisfied if the seats in at least one house of the legislature were based solely on the number of qualified voters in each district. It took Tennessee a couple of tries, but the state did ultimately come up with an acceptable scheme in which Senate seats were apportioned based on population and House of Representatives seats on geographical considerations. Other state legislatures across the country also ended up establishing electoral districts of equal population.
One person, one vote. I like it. Phew, that was a long discussion.
It was. Did you know that Justice Charles Whittaker actually recused himself during the case?
Really? How come?
He developed health issues, which also caused him to retire later that year. Some speculate the stress of this case contributed to his decline in health.
Wow, that's too bad. Hey, now don't you get up out of your seats. We've got more cases to learn about. What interests you the most? Independent judiciary? Famous cases? Civil rights?